The defendants argued that the advertisement accurately represented Mr. Posner's book and therefore could not be false and were also protected under the First Amendment. This did not answer the question, what about the attacks, the negative attack against Groden and the other assassination authors and researchers who were depicted in the ad. Besides which, going back to a Supreme Court case from the 1920s called 95 Barrels of Oil, the courts have construed ads in such a way that even if an advertisement makes a truthful statement about the advertiser's product, if it falsely attacks another person's product, it is false for purposes of unfair competition law. Whoops. So, the defendants brought their customary motion to dismiss, and after all the papers had gone in and all the oral arguments had been had, they brought up a new late argument that the Kennedy assassination is so controversial and seemingly irresolvable that since no one has ascertained with any certainty what happened, the ad must be taken as opinion. And that should sound familiar. We've been hearing that the past week as well. They also said finding a statement of fact in the advertisement would require this court to determine the truth or falsity of the conclusion of the Warren Commission. Well, you have to be familiar with the law of summary judgment, and in particular with a trilogy of cases that the Supreme Court decided in 1986 to understand what was going on here with these arguments. They were raising at the 11th hour the argument that Mr. Groden could not prove the advertising campaign false because he could not prove that the Warren Commission report was false. And that, under the precedents of the Supreme Court dating back to 1986, is enough to trigger a burden upon the plaintiff, in this case, to come forward and say, yes, I can prove the advertisement false. So we responded by letter to the judge saying we offer to prove, through what the government has represented to be the original autopsy x-rays of President Kennedy, that he was assassinated by more than one gunman, so that a jury may decide who is guilty of misleading whom. The defendants were relying upon analogy to libel law, and this is a form of commercial defamation that we were arguing over. The essential point is the statement is not protected if it states or implies assertions of fact which are provable as false. The standard is verifiability, and so is it capable of being objectively characterized as true or false? That's the test. The judge in the case, John S. Martin, Jr., did not respond to our offer to submit a response to the defendant's argument, and instead issued a decision stating that the plaintiff has failed to establish any factual dispute, and we failed to establish any genuine issue. He also stated that the proliferation of theories about the assassination is proof that there is no universally accepted factual answer to the question who killed President Kennedy, and therefore the ad must be interpreted as opinion. Of course, I could go through a whole treatise on the informal fallacies of logic and reasoning and how they apply to this kind of argumentation. Suffice it to say for our purposes today that the issue is not unanimity. The issue is, what is fair and just and what is the truth of the matter. And here again, the judge stated that they rejected the plaintiff's assertion that the ad is capable of objective verification. While this may be true hypothetically, the known evidence concerning the Kennedy assassination and the extensive debate over the Warren Commission's findings demonstrate that the actual facts will never be verifiable to everybody's satisfaction. Bear in mind, he had no evidence in front of him at the time that he wrote this. He also made several references to conspiracy theorists, referring to the people depicted in the ad. They are all conspiracy theorists of one sort or another. Even William Safire, the language expert of the New York Times, had remarked on the prejudicial character of this kind of epithet. What you do when you call any expressed suspicion, especially a complicated one, a conspiracy theory, you dismiss it as nonsense, the product of an unduly suspicious or even paranoid mind. Well, we did bring a motion to reopen, to reconsider, vacate the judgment. And this time we had, fortunately, with the assistance of Dr. Randy Robertson, who you met yesterday, and Dr. Wecht, and Bob Groden, we addressed the issue of the head wounds and whether President Kennedy had been shot once or twice in the head. I'm going to go over some of that evidence with you now. Just to review for those who are here for the first time today and who have not been following the controversy, the problem is that the autopsy pathologists found an entrance wound in the rear of President Kennedy's head, approximately 2.5 centimeters laterally to the right and slightly above the external occipital protuberance, which is a bony prominence in the back of the head, just above the fold of the neck. And this was outlined in their autopsy report. And they specified that in the underlying bone, they found a corresponding wound through the skull, which exhibits beveling of the margins of the bone when viewed from the inner aspect of the skull. Now, if you were here yesterday, remember the discussion between Dr. Bodden and Dr. Robertson, which Dr. Bodden insisted that there was, there may be a fracture at that site, but there's no hole. We're going to examine that a little bit more closely right now. And this is a diagram that was made by a fellow by the name of Rydberg, a military artist under Hume's supervision. Notice, if you will, the solid mass of bone between what is purported to be the entrance wound and the larger exit defect here. Roy Kellerman, the Secret Service agent who was driving, who was in the passenger side of the front seat of the limousine at the time of the assassination and who attended the autopsy that night, testified before our inspector that there was a space of about 2 inches here of bone between the entrance wound and the exit defect, and this diagram has it about right. Also, during the House committee proceedings, all three of the autopsy pathologists marked a skull at the location where they said the entrance defect was, and of course it agreed with their autopsy report. It disagreed with the Clark panel and with the majority of the forensic pathology panel for the HSCA. Here's a drawing that was done for the staff of the HSCA by Richard Lipsey, who was present at the autopsy, and this shows, as you can see, maybe I can point that out to you, and maybe not. I understand that this dot shows up very light in the back, but you can see that Mr. Lipsey has made a mark on the rear of the skull, which conforms to the location for the entrance wound in the head that was given by the autopsy pathologists. However, in 1968, Ramsey Clark appointed a panel of very prominent physicians to examine the autopsy x-rays and photographs in the archives. Actually, I believe that, they were appointed in 68. The report was not issued until January of 69. They found that the autopsy pathologists had been mistaken and that there was the entrance hole was actually 100 millimeters, 10 centimeters, 4 inches above the wound alleged in the EOP. So what we had was either a migrating wound or a second wound. Either the autopsy pathologists were mistaken or both sets of doctors were correct. This diagram, which was done by Ida Dox for the HSCA, shows basically the Clark panel version of the head wound, with which the majority of the FPP agreed. And you will notice that this diagram does not portray the transverse fracture that Dr. Robertson pointed out to you yesterday at the site where Drs. Humes, Boswell, and Fink placed the entrance wound